Good evening and welcome to the People's Platform. Now, the law is meant to protect and uphold the rights of those who seek legal redress. However, with the passage of time, with new understandings, new value systems and new circumstances and awareness, legal reform is necessitated. Today's topic will focus on one particular topic, divorce laws in Sri Lanka, the breakdown of marriage, loopholes and the way forward. To discuss this and more, we've invited to our studios a solicitor and barrister practicing in Australia, Dinesh Weerakkody. Good evening and welcome.
Good evening, Sonali.
Dinesh, my first question to you. When we take the marriage and divorce laws in Sri Lanka, we find the laws to be quite antiquated and based on what is called the matrimonial fault. So it's fault-based. There are just 3 grounds under which you need to base your divorce plaint. However, we don't accept irretrievable breakdown of marriage. However, in other jurisdictions, we see how this is being practiced. This is more amicable, this is more progressive. Speak to us about this stark difference in the antiquated marriage and divorce laws of Sri Lanka as opposed to divorce laws in Australia, for example.
As you pointed out, the main difference is we have a no-fault jurisdiction. That means we don't have to point fingers at anyone. If your marriage is irretrievably broken down, and if the reconciliation is not a problem, and if you've been separated for more than 12 months, that's it. And you can apply, if it's not a complicated matter, and the matrimonial division, in the sense property division, and child contact can be considered later. And you don't have to make it complicated by getting those things related to the divorce. And at the time of the divorce, of course, you have to mention if there are children, that the children are looked after. Basically, if the children are not homeless, and if they're looked after by at least one parent, that's also not a part of the divorce process. Mm-hmm. So it's not complicated in that sense at all. And you can go to courts yourself if you want and apply for a divorce. We don't even use the word decree. We just make use of plain language English and just mark it in on the website and apply. And when you actually apply online, you can choose the court date. And usually, depending on the court that they choose, the area, the geographical area, you may get a date within a month, 2 months, or 3 months, sometimes 4 months. But usually, you can choose the court of the area and choose the date. And on that date, usually the registrar, if it's not a complicated matter, will hear and make the decision, and you can download the decision. That's it.
Right. So we see that stark difference in Sri Lankan divorce laws as opposed to laws in Australia. Also, another point is that technology is used to the benefit of the litigants as opposed to the situation in Sri Lanka. Now, with the onset of COVID, something that happened was that we did start with digital hearings, which is still continuing. So there is a bit of digitization that is going on in Sri Lankan legal system, which is fantastic. However, because of the manual nature of the legal process, a lot of litigants find it difficult to sort of access justice expeditiously.
Access to justice is a key concept. Mm-hmm. And of course, as you're aware, if a person cannot access justice, there's no justice there at all. And a country that does not preserve law or the justice system does not cater, it's a failed state, if that is the case. But in Australia, we have law reform commissions, and we hear various parties, including various professionals, say for example child psychologists and so on and so forth, and make progressive decisions. So bills are discussed in parliaments and passed, and it's continuously changing to cater to the needs of the people and needs of the day.
Right. So it was interesting that you mentioned that, because even in Sri Lanka, with regard to reforming this area of law, there was a law commission report in 2006, a family law committee in 2010, which advocated the replacement of, among other things, the concept of matrimonial fault when it comes to matrimonial breakdown. However, we continue with these antiquated laws. When it comes to the concept of violence within marriages, and that is quite common in Sri Lanka as well, I'd like to draw your attention to this aspect of emotional abuse. How have laws in other jurisdictions viewed this?
It's the definition is quite wide. Now, when we use the term family violence, usually what comes to our mind is like physical violence. But the concept of family violence in Australia includes, as you rightly pointed out, not only physical or emotional. You've got, say, for example, physical harm to property or to your pets, or financial abuse if you are restricted in that way, and your bank accounts are restricted, or you're not given enough funds, and your movements are restricted. If there's dowry abuse and issues in relation to that, all that is, or whatever you can think of. Now you'll be sort of surprised to learn Australia is a Western country, but we accept that there is dowries and dowry abuse. So it's all it's inclusive, and it's a case-by-case assessment, and the court can decide whether, based on the facts, that there has been family violence. But before family violence, Sonali, if an alleged victim feels that he or she is threatened, you call the police and they attend to the incident, usually immediately or without much delay.
Right.
And if the nature of the allegation is serious, the police have the powers to give the alleged perpetrator an immediate, what we call in Australia, an intervention order.
Right.
That intervention order, it's called an interim intervention order because it's ultimately the court's decision.
Sure.
But the police are given this power through the system to issue that, through the court system, of course, and the alleged perpetrator may be required to immediately leave the place, the matrimonial home, and then follow the process, and the courts will decide whether they want to grant the intervention order and make it permanent, or have less restrictions, maybe allow the parties to live together if there's no indication of further violence, and have conditions. No family violence should be caused, or there may be a condition not to visit the residence or the workplace of the alleged victim. So likewise, it's very progressive, as you say.
So we see the role of law enforcement in prioritizing this issue of abuse and violence. So one of the major issues that Sri Lanka faces in terms of prioritizing this issue of violence and preventing it is that we're either short-staffed or we don't really give it the importance that it deserves. Before we get to the violence, how can we look at it in a preventative manner?
That is focused, say, for example, but I still would like to see more, and we have recommended further proposals, for example, anger management and training and counseling. Now, of course, in a developed Western countries, the counseling process is there, but Australia is a very multicultural jurisdiction or a country, and people coming from various parts of the world are still not used to, including, I may use people coming from certain Western countries, are still not used to counseling as such.
Sure.
But it's been discussed, and the discussions are currently ongoing to decide how to encourage people to eliminate issues rather than focusing on the issues after an incident. And even within the system, I mentioned intervention order process. So the alleged perpetrator can access anger management courses and then attend the final hearing and agree. And I'm being usually retained by people from various kinds of backgrounds. And they do sometimes realize and accept that they've got issues. Why? Because the system enables you to understand that situation when you're taken through that system, either voluntarily or through the process.
Sure.
And I find that amazing. Usually in certain countries, or even in that situation, of course, there are people who doesn't agree that a person has an anger management issue or some kind of a psychological or whatnot issue. Because I'm not I'm a legal professional, but I can see sometimes admissions are not made, and you don't have to, but the reconciliation process gets delayed if one party is not willing to participate in a discussion.
Right.
And people, usually alleged perpetrators, have a tendency to blame the victim.
Yeah.
And victim blaming is not accepted in Australia anymore, at least within the judiciary, very specifically through a discussion of the Law Reform Commission.
Right.
So even in sexual assault cases, you have certain people have tendency to blame the victim.
Right.
That is not tolerated anymore.
Okay.
And that discussion has moved towards a communication model. So you always need to...
Can you elaborate on the communication model?
Say, for example, I'll give you an example. In a sexual assault case, let's say the consent is quite important. A prior consent to a certain act, like two adults consenting to do a certain act, is accepted, but then consent can be withdrawn. But silence is not consent. So the alleged perpetrator should have done something to ascertain whether the consent has been withdrawn or the consent is still ongoing. So we call it, the Attorney General has called it the communication sort of model, communicative model. So it's an ongoing process. So perpetrators needs to be aware of these and be very careful. Right.
I noticed that you also spoke about financial violence. This is a tactic that is used especially in lower income families in Sri Lanka. A lot of the women who get beaten up by husbands or boyfriends say, look, I don't know how to feed myself and my children if I leave my abuser. Therefore, I have to stay with him. So financial violence, economic abuse, this is very much an issue. In terms of legal reform, how do you think this can be sort of rectified?
There's a lot of support to alleged victims, and also, for that matter, perpetrators as well. For example, there are safe houses. There are places that people can go to with their children. And say, for example, if an intervention order is given, if the alleged perpetrator is not allowed to visit home, the alleged victim can stay in the matrimonial house. That person will not be kicked out as such. But there are, of course, certain practical issues. Of course, they will not be able to maintain the same lifestyle. They will have some difficulties. That's an unfortunate part, because every aspect cannot be dictated or laws cannot be implemented to resolve all problems. Certain problems needs to be dealt with as private matters.
Right. One of the key aspects that you also spoke of is that of psychosocial care, and how the legal system also needs to incorporate psychosocial care, counseling, anger management training for people who are going through issues. This is something that is very much absent under the Sri Lankan system. In terms of reform, again, in your opinion, how must we sort of look at bringing this in?
One way is, of course, through legal reform. The other is education, awareness sort of thing, which we've usually hear in any aspect, say, for example, whether it's environmental conservation or whatnot, the awareness side.
Sure.
But what my observations are that we are still at a very primitive level in relation to this aspect, the topic that we are talking about. I've never heard of an anger management course. I mean, there may be, I don't know, but it's not widely available or widely seen. In Australia, of course, when alleged, I act as a defense counsel as well, and in relation to property divisions or joint consent agreements, I act for both parties if there's no conflict of interest. And one thing that we emphasize is go and get help, to go and get help. And if we see in allegations elements of anger or any other issue, we encourage them always. And that is a part that a court would like to hear before making final decisions.
Right.
Even in criminal matters, I act as criminal defense counsel sometimes. When a family law matter arises, sometimes you're charged with criminal charges or acts.
Okay.
For example, assault, serious assaults, aggravated assault, and so on and so forth, in addition to intervention orders. So a matter may start off with an intervention order. That's a court intervening to stop the issue as much as possible through legal mechanisms.
Yeah.
And an intervention order is a civil matter. It's not a criminal matter.
Right.
But Sonali, if the alleged perpetrator is not serious enough or don't understand, if he tends to breach the intervention order, that's the court order or the temporary order that is given to stop the violence, it becomes automatically, as soon as the breach happens, it's a criminal matter. And you are then facing criminal charges for breach of the intervention order on top of, if there are allegations, the police will start charging you for under criminal act and regulations.
Right, right, okay. So in Sri Lanka, we get the Domestic Violence Act to deal with gender-based violence.
You are more competent in that. I'm not a lawyer practicing in Sri Lanka. I've just observed certain things.
Absolutely, and the courts can issue protection orders, again disallowing the alleged perpetrator from coming in contact with the alleged victim. In terms of, let's talk a bit about the children who suffer the brunt of these toxic marriages, especially because in Sri Lanka, divorces, contested divorces, are just long drawn and messy, because mainly due to the fact that this is, it has everything to do with a fault-based kind of model. How do we move beyond this?
In Australia, if the situation indicates that there's been child abuse. Now, remember, as soon as the word abuse is used, we think it's like physical abuse. No, observing the alleged perpetrator abusing the alleged victim is also child abuse. And if the matter goes to courts, a court may intervene and appoint an ICL, what we call an independent child lawyer,
right,
to protect the interest of the child. Because sometimes the alleged victim, let's say in this instance, we'll take an example as a mother. If the mother is not aware of the legal situation, that is the children's or the child's right, despite whatever going on with the parents, the child, if it is not abused, have a right to be with their parents, his or her parents, both parents. So the child contact is evolved, and unless the child has been seriously or in a way abused, it's a balancing act, of course. The child's right to be with the parents and the abuse. And the courts appoints, as I said, an independent children's lawyer, and they will observe and make recommendations or representations on behalf of the child to the court in a disputed situation between a mother and a father.
Right.
And that way the child's rights are preserved. And then if the parents were unaware of the child's right, now usually in a situation you talk about the person talks about his or her right, and the other person will talk about, that's usual, their rights. But they usually forget the children's rights. And another aspect is, if the child has been really abused and the child has no protection, the child can be taken away and given to a different family. That's a serious step, of course, in unusual circumstances or in serious circumstances.
Okay. Now, under Sri Lankan law, and we are talking about legal reform and how important it is and how urgent it is to ensure that we have legal reform when it comes to marriage and divorce laws in Sri Lanka, the concept of marital rape is not recognized under Sri Lankan law. How dangerous is this?
Rape is rape, whether, as far as we are concerned in Australia, whether you are in a relationship. In fact, Sonali, the statistic shows abuse and rape happens within relationships. So I'm surprised to find out that Sri Lanka, we still don't recognize that fact. Usually when you're abused, you're not abused statistically by a complete stranger. Now, of course, that might happen. But the statistic shows most of the situations are within close friends or in a relationship. So, and also another point, just going forward, just to realize that we've got Kandyan law for a certain a cohort of people, and Tesavalame for another, and I think Muslim
law.
Act. It's based on race, religion, or whatnot, language. At least race and religion, the decision or the basis. In a way, to have laws in such a way, complicated laws based on race and religions, is in a way pretty disgusting. So I'm very concerned the way the law is operating in Sri Lanka, especially in this aspect, because people who are in a troubled relationship are already emotionally, financially are very upset. They don't need to go this complicated and archaic way. And I don't know how it happens if you're let's say a Tamil or a Sinhalese or a Muslim, whatnot. I don't know how the law is in that kind of marriage. Maybe you decide I'm going to marriage under general law or whatnot. Then the other party who are from a different background, may feel alienated and may not understand why I'm dragged into this law. So it's pretty concerning, and that's why I suggest urgent reforms. Now, urgent means not in 2-3 years' time. Immediate reforms should be undertaken by the government and actually implemented. Now, you said the commissions have been given reports, I don't know. But implementation, we're still having the same laws. No changes have happened. So what's the purpose of having these meetings or gatherings?
Right. Let's also talk a bit about how the judicial mindset needs to also incorporate these new developments in the laws.
Now, judiciary, of course, in here I'll include the lawyers as well and the judges. Sonali, every year we have to do what we call CPDs, continuous professional development courses, to renew our practicing certificate every year. And if we don't get our practicing certificate renewed, and we can't practice. And in every matter we take, we call it a retainer. When a client retains us, we have to, this is another separate thing that I'm going to point out, we have to give a cost estimation to the client. We can't charge nilly-willy when we see the person depending on what he or she wears. We have to give a fee estimation. And coming back to your question again, so through these law reform commissions and through CPDs, the professional developments, we get professionals through our law society, and we hear those professionals discussing about various aspects, latest developments, and we update our knowledge. And we get educated. And the mindset of the judiciary has shifted from that victim blame situations and has progressed. So even if you're not a lawyer, if you go to the judiciary or to a lawyer, they will up to a certain extent tell you what I'm not certain extent, they'll definitely tell you what the law is, but also that acts as a sort of an educational sort of process to your clients. They'll understand the law. And it's a lawyer's duty to explain the process very clearly. And I believe, and I understand and have experienced, I may be criticized by a certain section of the bar or lawyers here, but I should say what's in my mind. I don't think the processes would be explained by your lawyer. You might have instant advices given, okay, you do this and come. You don't know why am I to do this. You don't know the ultimate, the process or what you have to go through. And if that is the case, it's also a very, I'm troubled by that. When I see and listen to my clients, especially now if a divorce is granted in Australia, apparently that is not a straightforward case for a dual citizen or a Sri Lankan national who even temporarily living in Australia to recognize that as a divorce in Sri Lanka. But Australia, on the other hand, if a person is, say for example, married in a country in a legal way, that marriage is accepted in Australia as a legal marriage. Similarly, a divorce. We don't need to register. If we have a divorce decree, I think we call it nice or decree absolute. We don't use that word in Australia now. A divorce is a divorce. In Australia, we don't use those old language at all. And you see sometimes in powers of attorneys in Sri Lanka, what sort of word they use. We have a plain language policy. So our clients ask us, now I'm not a lawyer in Sri Lanka, and I can't explain it, but I understand when I even advise you, ask your lawyer what the process is. They say, oh Dinesh, I have to get a separate divorce. What? You're already divorced. You're Sri Lankan. Because we take into consideration the Sri Lankan marriage certificate, a person living in Australia can get an Australian divorce based on the Sri Lankan marriage, not a problem, because we accept it. But then when it comes to Sri Lanka, it's a problem.
It does get complicated when foreign decrees are not recognized. But there is one act, and there's I think a pending draft bill that's yet to be finalized and presented. So we can look forward to that.
Hopefully.
We're going for a short commercial break. We're discussing a bit of a technical topic, but it's important. So stay tuned.
මේ රටේ සියලුම දෙනාට සාමකාම උද්ඝෝෂණය කිරීමේ ඒ අයිතිය තිබෙනවා.
සෑම ආණ්ඩුවක් හදනකොටම ජනතාවට විශාල බලාපොරොත්තු තිබෙනවා.
ජනතාව වෙන්න කිව්වොත් එනවා. ජනතාව ගෙදරලා ඉන්නකොත් ඉන්නවා.
බඩු මිල දෙතුන් ගුණයකින් ඉහළ ගිහිල්ලා තියෙනවා. ආදායම ඉහළ ගිහිල්ලා නැහැ.
ඒතර ඒක තමයි පාලක පන්ති අරමුණ.
කවදාවත් වංචාවක් දූෂණයක් කරපු නැති කෙනෙක්.
බදු ආදායමක් ඇවිල්ලා තියෙනවා.
එන මහකරණයෙන් පස්සේ ආයේ මේ රටට හාල් ගේන්න ඕනේ නැහැ.
හැමතිවරු 70ක් ඕනේ. බංකොලොත් වෙලා තියෙන රට.
ෆයිනල් කාඩ් සතියේ දිනවල සවස් 4:30ට.
ඔබ දියවැඩියා රෝගියෙක් නම් ඔබේ ඇස් දෙක අන්ධ විය හැකියි.
විය සහායක සහ මධ්‍යම පරිමාණ ව්‍යාපාරිකයන්ට සමාජයේ කතා කරන්න තැනක් නැහැ.
අපි තීරණය කරුවා හැමදාම බැට කනවද රට දාලා යනවද එහෙම නැත්නම් අපි විසින් මේ හොඳ පිරිසක් එකතු වෙලා මේ රට දේශපාලන නිලධාරීන්ව පාලනය කරලා හරි මගට අරගෙන මේ රට කෙලින් කරනවාද කියලා.
ව්‍යාපාරිකයෙකුට මුලින්ම අර ප්‍රාග්ධනය කියන එක හොයා ගැනීමට අපහසු නිසා අපි ප්‍රාග්ධනයට අවශ්‍ය දේවල් පහසුකම් යන්ත්‍ර සූත්‍ර ටික ස්ථාපිත කළ දෙන විශ්වවිද්‍යාලය.
ජාතික මෙහෙවර සතියේ දිනවල උදෑසන 10:00ට TV1 ඔස්සේ.
Welcome back here with the People's Platform. We're in conversation with Dinesh Weerakkody, a solicitor and barrister practicing in Australia. Dinesh, we need to talk about gender stereotyping within marriage, the changing role of the woman in a marriage. We find that sometimes women are homemakers. They look after the children and maintain the homes while the husband goes to work. However, their role, the unpaid labor, is this accounted for? In Sri Lanka, it is not, technically. How is this looked at under Australian law?
Again, I'm learning from you, and I'm disappointed to hear that it is not recognized in Sri Lanka. Women, mothers, play a substantial role in certain instances to their detriment in relation to their career progression, if that is the case, or personal development.
Yeah.
That is very much recognized in Australia, equal to the breadwinner. So, say for example, if a matter goes on a property division to courts, that time that the mother has spent as a homemaker is equal to the breadwinner, because the father or whoever, we have reversed roles
Sure.
as well in Australia. Whoever earns money can do that because of the support of the other party.
Yeah.
And that party is losing the career progression and their time. And after a separation, we take into consideration the future prospects of that person. Say, for example, if you are a career professional before the marriage, and due to the marriage you spend 5-10 years looking after the children, you won't get promotions all of a sudden if you want to enter the workforce.
Yeah.
That is taken care of under a fair and just and equitable division of matrimonial asset division. So that's very much recognized and is considered equal.
I'd like to move back to this point of, since we're talking about gender roles, aggression within families and the need for psychosocial care. Do you personally believe that this needs to only come from the state, or that that parties themselves should educate themselves so as to seek mental health services whenever required?
Now, this is not a legal opinion, but
Sure.
a personal opinion. I think it's a mixed thing. So the state's responsibilities are separate, and private responsibilities are private responsibilities. But the state, I think, should make the laws that is within their jurisdiction to make it possible, or force people to go through that pathway. And of course an awareness through the within the school system to recognize gender equality. Now that's a whole different subject. Now Marriage Act permits people living together with different genders or same gender, it doesn't matter. A relationship between two parties is a relationship between two parties. It doesn't have to be between a male and a female. Now that mindset is not, I know it's not there in Sri Lanka, and people who are looking now watching us may think, what's that? That's not for us. That's not for our country. Well, it's your decision. I'm just telling what's happening there. So on the other hand, that system in Australia promotes self-realization and educating yourself and attending those trainings. Otherwise they'll be, if they're in trouble, it's very difficult for them to get out of that situation. The court recognizes those participations. So that is in a way encouraged through the system. And people now realize it, and there are even people coming from our culturally diverse backgrounds realize the importance of attending these courses. And as I said, some realize and move forward. So it's having relationship issues is not the end. They can always bounce back.
Right.
And that is promoted in our system directly and indirectly.
Yeah, so this requires a paradigm shift in attitude, because in Sri Lanka, a lot of women especially are trained to think that if you go through a divorce or if you go through a separation, it will be looked at with a lot of stigmatization. Whereas it's, you know, if two people can't be in a relationship, you move out, right? There's nothing crazy about it.
No, the
yes. Normalization of
Correct.
A breakdown of a relationship or marriage, I think that's what's lacking, among other things, in Sri Lanka.
There's another aspect to that. When parents are invited sometimes to live or for a short visit, and sometimes indirectly parents pressure their children not to move on because of the situation in their own countries and the pressure or whatever the stigmatization that the parents will face in their country, but nothing to do with the welfare of the alleged victim or the person who's going through that system, which is concerning.
Yeah.
And I've dealt with many clients who tell me, look, I can't live. I want to commit suicide. Now, suicidal thoughts are very serious. People do commit suicide. But because of the parents, because of the pressures, and to keep parents happy, they don't. Now, I'm not encouraging separation or divorce. I'm just telling facts as facts.
Yeah, absolutely.
And in Australia, we don't tolerate violence at all, even towards your children.
So violence encompasses physical violence, emotional violence, financial violence, sexual violence.
You name it. If it is not civil, if it includes any kind of emotional property through pets, some kind of a violence, it's caught within that broader definition of family violence.
Sure. I'd also like to draw the attention of this conversation towards policy making and budgetary allocation. In Sri Lanka, much of the budget is allocated towards defense, development projects, and we have abysmal allocations when it comes to child protection, welfare of women and children, marriage and divorce, counseling, psychosocial care. So speak to us about the importance of prioritizing these aspects.
The last Labour government in Victoria, they had an election promise to focus on family violence, especially violence against women.
Right.
Now, I don't think in the past we have ever heard a major policy or an election promise taking action against family violence in Sri Lanka. I'm not sure whether we'll hear it now or in the near future. But that shift was there and it was actually implemented, and we can see the results now.
Right.
A substantial amount has been allocated and is now being used for implement and have systems, safe houses for women and children, and training. So I guess that's another stark difference between the changing mindset of the Australian politicians and the judiciary, and through that it's an education sort of process to the people as well. Because people don't go and participate in experiments or learn about experiments and whatnot, but through the system, in a way, they are directly influenced to learn and follow the process.
Yeah. So just to wrap up the conversation, Sri Lanka's divorce laws are quite antiquated, fault-based, so you either need to come under malicious desertion, adultery, or incurable impotency. It's quite rigid. And it does not recognize irretrievable breakdown of marriage, although this has been advocated for by several law commissions and committees in the past. How urgent should law reform be in this aspect of divorce law?
Well, it should have been done long time ago. Now, I'll emphasize the fact that I'm not advocating for divorces, just nilly-willy or separations. We are using the term irretrievably broken down relationships. They should not be forced to be in an abusive relationship when the relationship has been broken down. So everything that I'm talking about here and the policies are in relation, not advocating for separation, but in situations where the marriage is already broken down. We are not trying to break relationships. These are unworkable relationships. We are trying to make it easier for people to move on. And it should have happened long time back. And if not, it's very urgent for people to move on. The mental agony that people goes through in these processes, it doesn't stop with a divorce or a separation. It continues. And countries like that, it sort of continues forever because of the stigmatic or the stigma that is attached to it. That mindset, mental shift, I don't know when it will happen, but at least initiative should be taken by the policymakers and the lawmakers of the country. That's quite urgent. Just do it.
All right, fantastic. Thanks very much for joining us on this edition of the People's Platform. Dinesh Weerakkody, thanks again.
Thank you for inviting me.
No problem at all. Thank you for watching us. We'll see you again on Monday with the Sinhala edition of the People's Platform. We're planning to talk about suicide prevention. We will be having a few resource persons coming in. So make sure you tune in. Have a safe weekend and good night.
Newsfirst News Alert ඔබේ ජංගම දුරකථනයටත් ඔබ ඩයිලොග් පාරිභෝගිකයෙක් නම් English Alert සේවාව ලබා ගැනීමට NFU ලෙසත් Singlish Alert සේවාව ලබා ගැනීමට NUS ලෙසත් Tanglish Alert සේවාව ලබා ගැනීමට NAT ලෙසත් ටයිප් කර 678ට සෙන්ඩ් කරන්න.
Open, honest, hard-hitting.
Unearthing the real facts, cutting through the noise.
Going the extra mile at whatever cost. Relentless in the pursuit of the truth.
Connecting the dots, revealing the bigger picture.
What matters to you matters to us.
Because this is our nation. It's